Here comes the magic. Ta-da! What is the difference between a will and a trust? And if I have a trust, do I need a will? If I have a will, do I need a trust? Some version, some variation on a theme. I get those questions off. A will is a document that alerts the world. This is what I want to happen to my assets now that I am deceased. I want this person to be my executor, and I want that person to get my house, and I want this other person to get my brokerage account. Right? That's what a will does. It is useful and only has force and effect after a person passes away. That's a will. A trust can be a will substitute. If you have a last will and testament and you have a simple plan, if you want to distribute things evenly, 3 children, 3 separate ways, 2 children, 2 separate ways, with certain specific bequests, you can use a will, and it can be fine. And if your plan, your idea of how to distribute your assets and your circumstances are simple, a will can be a perfectly valid legal document and sufficient for your needs. And in that instance, you would not need a trust. But do you see how I had a few thoughts ahead of saying, before saying all you need is a last will and testament, I qualified it. So this is a qualified circumstance that if you have a will, you don't need a trust. And it has to be what you want. Conversely, if you have a trust is a will substitute. It can have present-day force and effect. It can protect and provide for instructions if you become disabled. And if you have a trust, and there's the qualification part, qualified answer, if you have a trust and all of your assets have been funded into the trust, placed into the trust while you're alive, then you don't need a will, but it's qualified. And if you do a trust with me, I also make sure that you have a will. It makes sense for any after obtained assets, anything that you might have inherited before you pass away, anything that you may buy or purchase before you pass away that didn't make its way into the trust. I think you need both. And the difference is, well, there's quite a few. A will is required to go through probate, and a trust is not required to go through probate. A certain type of trust can be a will substitute and a probate avoidance vehicle. That's it for now. Otherwise, I could keep going and inundate you with information. But I'll give you a little bite-size, little chunklet of information now. And later on, we'll give you a little more chunks of information. I have clients, husband and wife, that I prepared a trust for them. It's an irrevocable trust. 2 different types. There's either a revocable trust or an irrevocable trust. And the trust itself is a versatile estate planning document. It's a strongly, versatile? No, that's not even a word. It replaces the will. It supplants the will. It's better than the will. However, we should also do a will. Why? Because if this particular couple does not properly retitle or fund their assets into the trust will have no force or effect. It'll be a document bereft of any money. So it's like having a bank account. It's not a perfect analogy, but say you have a bank account with $100 and all the rest of your money is under your mattress. Well, the bank account doesn't have enough money and your bed is holding the rest of the money. I don't know. I thought of this example on the fly. To drive the point home, your assets have to get into the trust, and the will would do that. It's not the best way to retitle assets, but at least it's a method so that you don't have unanswered questions or assets that don't go in the right place. I don't know. I guess it's a long day. But if you need an attorney, I'm here for you. FrankBrunoLaw.com.